I'm seeing that there is at least enough to determine probably he was involved in the conspiracy to commit the misdemeanor. Well, to have the stolen property. He had stolen property. So if you want to, I can dismiss all counts. There is definitely enough there to connect that. Whether, and you agree, Mr. Harrington, yes, you're nodding your head up and down. Yes, you agree. And even in your brief, you agree that there is enough to say, Mr. I can't even say that. Even in a preliminary hearing, I can't say, I find probable cause that a burglary was committed, because the law says I have to determine probable cause of a felony or probable cause of a misdemeanor.
This judge is one of those rare ones who actually reads every single word on the police report, and you can literally feel the prosecutor sweating while she does it. Most judges just breeze through these hearings, but she's treating this like she's grading the SATs. The whole vibe is her saying, if it's not on the paper, it doesn't exist. And the prosecutor is losing his mind because he knows the report is missing half the details he needs. It turns into those quiet battles between legal technicalities and plain common sense. And honestly, it's kind of hilarious watching her refuse to fill in the blanks for him. I love hearings like this because it shows exactly how fragile a criminal case can be when the details aren't locked down perfectly. Let me know if you think judges should go strictly by the paperwork or use a little bit of logic when the situation is obvious. Let's dive in.
Set here today in this matter for a motion hearing, a four corners motion hearing, the criminal complaint, which is a 38-page criminal complaint in this matter. However, with regards to that, there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 charges in that criminal complaint that does contain 38 or 36 counts, criminal counts, but 12 of those counts relate to defendant Robert English. We are here today for the court to hear any arguments to supplement the briefs, because again, this is I want to say a complex, or it has a lot of facts and things alleged in the criminal complaint as well as in the arguments. So I am going to start with Mr. Harrington. This is your motion. Again, I have thoroughly read your brief along with the criminal complaint. As it relates to this case in any argument, what would you like to state?
Judge, nothing. I'll rely on my brief, except anything that I quoted in the brief, cited in the brief, was based upon either a review of the cases that I cited or the jury instructions. I'll stand on the brief. Thank you, Judge.
All right, thank you. Mr. Schmidt?
There's a reason why the test for adequacy of a criminal complaint is described as common sense and not hyper-technical. If the complaint was only one sentence long and the one sentence was 4 people who reside in Burnett County reported their house was broken into, damage was caused with the breaking in, and stuff was stolen, and the stolen property from all 4 were found in Robert English's bedroom, that would be an adequate complaint. This complaint actually contains that information as well as a plethora of other information. The court has already found probable cause for all 12 accounts when it issued the arrest warrant. Attorney Harrington has not pointed out anything I think the court missed. Thank you.
All right, Mr. Harrington, any reply?
No, I'll stand on the brief.
All right. Again, the court has reviewed both of the briefs that have been submitted by the parties in this case. First, the court must address the issue of the arrest warrant and the argument that the court has heard that the court found probable cause when it issued the warrant. This is not entirely accurate. The court did find probable cause that a crime was likely committed or probably committed, but not that a felony was probably committed or which of the crimes could have probably been committed. And there's a difference. A preliminary hearing would determine whether or not there is enough facts or evidence alleged, even with inferences to the state, to determine whether a felony was probably committed. Whether or not the burden has been met with an arrest warrant of a crime being probably committed, it's determined about the facts alleged, and the court did determine that a crime was probably committed and issued the arrest warrant.
The judge is walking through that complaint line by line like she's looking for a missing comma, and the prosecutor is sitting there realizing her entire felony charge is hanging by a thread. She literally tells him, I'll give you the misdemeanor, but you didn't prove he broke the window. And I swear I feel like she just slapped him with a big red F on his assignment. I mean, if you want to call something a felony, you need actual evidence written down. You can see the prosecutor fighting the urge to argue because he knows the facts are on his side, but the writing isn't. And this judge is not about to let a half-finished paragraph turn into a felony. I mean, she's completely in the right here, I think. Let me know what you guys think. But she's just so laser focused on probable cause, not the vibes this guy's got going on. And she's really not giving him a single inch right now.
Second, the court has thoroughly and carefully reviewed the criminal complaint multiple times while examining both of the submitted briefs. The court has reviewed the voluminous communications within that criminal complaint, which would be text messages between the co-defendants. Those written communications among the parties discuss potential burglaries, which then would give the inference or the connection to the criminal damage to the property and perhaps possession of stolen property or misdemeanor theft, moving of property. However, those conversations, specifically in reviewing each of those texts very specifically, those conversations do not implicate Robert English in any of the burglaries, which would then connect to the criminal damage to the properties, only that they may relate to the probable possession of stolen property or movable theft or theft of movable property. So in the court's review, I cannot find the evidence or the facts presented in the criminal complaint to connect Mr. English and the commission of the burglaries and the connection to the criminal damage to property. Could Mr. English could he have possibly known about the burglaries? Yes. Could he have possibly helped in committing those burglaries? Yes. But in the review and as the facts and statements and the specific details are laid out in that criminal complaint, reviewing the criminal complaint and what's laid out in detail in that criminal complaint, it would only be speculation or conjecture because of the close connection Mr. English has to the co-defendants. One of the co-defendants is his girlfriend of a significant long period of time, and the other co-defendant is her brother. But there is that close connection in those written communications as to the likely stolen property and it being in possession of or going to be or something to be done with, probably with Mr. English. There's a connection to that. Even as stated in the criminal complaint, in reviewing and looking for the conspiracy requires a mutual understanding to achieve a shared criminal goal and to work together to carry out that criminal plan. There must be some type of either words or actions or intent by the defendant to complete that crime in the criminal complaint. As again, it is laid out and described in specific detail. The court can't find anything that indicates a conspiracy without having mere speculation or conjecture. This is insufficient for the court to link the defendant to the crime of burglary or to the relation with the crime of criminal damage to property. Although the state does correctly state that conspiracy does not require the co-conspirators to have an explicit or formal agreement, meeting, or even know each other, there still must be more than speculation or strong opinion or belief to link the parties to committing a crime like burglary or criminal damage to property. The details and the specifics as related to the burglary and then the criminal damage to property as outlined in that criminal complaint in the court's review does not provide sufficient inference to connect Robert English to those acts. This is in contrast to the court's review with the allegations of the possession of stolen property, theft of movable property, those and the conspiracy to commit the misdemeanor theft as a party to a crime with that movable property. The court determines that that criminal complaint contains enough facts and specific details to reasonably believe and probably believe that Mr. English did commit or co-conspire to commit those crimes, allowing those charges to move forward. But with regards to the burglary and the criminal damage to the property, the court cannot find enough to connect, even with an inference, without mere speculation or conjecture, to connect Mr. English to those crimes. So I'm believing you understand that the court is saying with regards to the charges, the court can only find enough to connect as it relates to the conspiracy to commit misdemeanor theft as a party to a crime with the movable property. So I believe that is only counts 6, 15, 24, and 33. Mr. Harrington, you look like you want to say something.
I haven't thought through what I want to say because I think those are all misdemeanors at this point, aren't they?
They are.
I guess As I recall the rules, Mr. Schmidt has the opportunity to amend the complaint
He does.
rather than a dismissal. And I guess I want to know how long it's going to take him to amend the complaint and where we go from there. Suggest that maybe the court set this for a status.
I'm not going to amend the complaint. We need to do the prelim. We need to get this case moving. One of his co-defendants has invoked speedy trial.
Fair enough. We'll set it for preliminary exam. I have time. If the court is finding that everything except 6, 15, 24, and 33, the complaint lacks that. The motion is an attack on the personal jurisdiction. I think there has to be an amended complaint. These are misdemeanors. We're not going to have a preliminary exam on misdemeanors.
We would not.
I thought the court dismissed the crim damages.
And the burglary.
So the court found probable cause to believe that Robert English was knowingly in possession of stolen property from the theft, which is an essential part of the conspiracy, but would not find the burglary and crim damage that were necessary for the theft, even though the conspiracy jury instruction says he doesn't need to know about those or be part of them.
I think
That's
that's
my
precisely what the judge found, and I agree with
That is
that.
exactly what I found in the review of the criminal complaint. And again, you do have the ability to amend the criminal complaint.
Now we've hit my favorite part. The prosecutor basically goes, "Judge, come on, use some common sense," which is the fastest way to get shot down in a courtroom. If you guys haven't known, he's trying to argue that if the guy had the stolen stuff, obviously he broke the window, and she stops him instantly. I mean, you can practically hear her thinking, that's not evidence. That's just a guess. And honestly, I really do respect that because we've all seen it. Like, assumptions are just how innocent people end up in jail. Like, we've all seen that stuff. I would definitely rather have an annoying stick to rules judge than one who just fills in the blanks herself. But now we see the prosecutor spiraling and throwing out case law like it's going to magically rewrite the police report. Meanwhile, the judge looks like she's wondering how this became her problem. Honestly, it's pretty funny to me. I don't know. There's just something about this prosecutor that's just weird to me. I really can't put my finger on it. But let me know what you guys think about him.
Reviewing the jury instructions for conspiracy, it requires at least a mutual understanding and a shared criminal goal to work together to carry out a criminal plan. He would need to know that the burglary was going to be in existence. And I can't find that there is any connection.
It does not require that you all have the mutual understanding of the same crime, just a criminal purpose. That's why the jury instruction reads that.
Again, I can't find in the facts, especially in looking at the text messages and the communications between the co-defendants, that Mr. English was involved in the criminal purpose of the burglaries. Did he possess the stolen property? Probably with the facts.
That's what I'm getting at with the conspiracy in this. It's really all or nothing. If the court believes that he was part of the theft, as in he knew the property was stolen and possessed it, he's also party to a crime conspiracy on those others. It has to be all or the other when it's all part of one scheme.
But not necessarily. There could be a scheme. I don't see a scheme here. I see any individual could receive stolen property from their friend Joe. Joe could say, "Hey, dude, I stole this. I got this. Let's sell this." Doesn't mean that the guy was a part of the decision to steal the property.
Then the court couldn't bind over on the theft because that has a knowing element too. That's the problem.
Well, I find that there's probable cause to believe that he was in possession of stolen property and knew that it was stolen.
So is the court actually dismissing all counts then? Because we didn't charge receiving stolen property.
Again, you can amend if you wish. I'm saying there's enough probable cause to believe a crime was probably committed. What that crime is and how it's laid out is for the state to prove. I'm seeing that there is at least enough to determine probably he was involved in the conspiracy to commit the misdemeanor. Well, to have the stolen property. He had stolen property. So if you want to, I can dismiss all counts.
I am
But the
not
state-
amending and receiving stolen property. If the court is not finding probable cause for all three counts, that's what I'm checking.
Mr. Harrington, if he does not want to proceed with the other misdemeanors that are
I
stated.
didn't charge receiving stolen property as a thing. The court's saying it's only finding probable cause for something I didn't charge is what I'm hearing.
I think the judge addressed me. I'm to answer the question. that
Yes,
the court
Mr.
posed.
Harrington.
As I mentioned, the rules require or give the state the opportunity to amend where a court finds that there's not facts sufficient in the criminal complaint to impose the jurisdiction of the court over this particular defendant. The state has that right by statute. What Mr. Schmidt is arguing the court decided that there aren't facts sufficient to connect those inferences that they want to have connected for the felonies. As I understand the court's decision, the court found that there is no basis for the conspiracy as it relates to the burglary and the criminal damage to property, but that there is for count 6, 15, 24, 33, those are misdemeanors. If Mr. Schmidt wants to amend, fine, but I don't view that we need preliminary exam for those particular crimes. They're misdemeanors, even if it's
We do
misdemeanor.
not. And that's the court's view is I find probable cause that a crime, a misdemeanor crime was probably committed by Mr. English. There is definitely enough there to connect that. Whether, and you agree, Mr. Harrington, yes, you're nodding your head up and down.
Yes.
Yes, you agree. And even in your brief, you agree that there is enough to say Mr. English probably committed.
There's probable cause to believe.
Correct. There's
Set
probable
forth,
cause
yeah,
to believe
yeah.
that he did commit misdemeanors. Whether or not the state wants to continue and to pursue the misdemeanors as charged, that's a determination for the state.
Correct.
The court is not dismissing those misdemeanors. As stated on the record by Mr. Harrington, and I have them written down somewhere as to what they are. But I don't have them, I don't know where I wrote them down on which. 15, 18, no,
6, 15, 24, 33, Judge. Those are the ones you recite out of the record.
correct. Those misdemeanors stand in the court's review of determining probable cause that a crime was probably committed by Mr. English. The other allegations, the court cannot find any connection as laid out in the criminal complaint. But again, the state has the ability to find other information or to put other things in that criminal complaint that would tie it to a conspiracy for criminal damage or conspiracy for burglary. I just can't find it. And I'm going to tell you, I reviewed that 38-page criminal complaint at least 3 times, perhaps more.
Here's the issue of confusion I'm having. I'm hearing the court saying it's finding probable cause for the counts that are misdemeanor theft, movable property, where the state's alleging that Robert English took property out of the home during the
No,
burglary.
that is not what the court is saying. The court is saying, just like any preliminary hearing, when I have
This is not a
Mr. Schmidt, it's not, but this is my example to show you. In a preliminary hearing, the court has to find probable cause to believe a felony, not the felonies that are charged by the state, because sometimes the state charges them wrong, or sometimes the state doesn't add additional felonies that they could find. In court's review of a complaint as it relates to misdemeanors, and Mr. Harrington can tell me if I'm wrong, in review of a misdemeanor criminal complaint with misdemeanor charges, the court has to determine if a misdemeanor crime was probably committed and probably committed by the defendant, whether or not the state has accurately and correctly charged the crime that should be charged. Am I not correct, Mr. Harrington?
You're absolutely correct, Judge.
Absolutely correct.
I don't believe that's correct. I think when it's a four corners motion, you challenge the actual counts in the complaint, meaning the court's not deciding whether or not a misdemeanor occurred when it reviews the complaint. It's deciding whether there's probable cause for each of the counts in the complaint.
Mr. Harrington,
That is how 96801.
if you want me to dismiss all of the counts, I surely can, but I'm finding that there is probable cause to believe Mr. Robert English has committed a crime, and in review of the criminal complaint, as it is stated with every single word in there, probable cause to believe he committed misdemeanor crimes.
That part literally made me laugh out loud. The prosecutor tries to guilt the judge by saying it's a waste of time to just pursue the misdemeanor, and she hits him with the coldest response ever. Okay, then I could dismiss everything. That's the courtroom version of say it again. I dare you. I swear you could literally feel the energy in the room shift instantly. The prosecutor went from frustrated to terrified in 2 seconds. He had a backpedal, so fast the shoes probably melted, and honestly, he brought that on himself 100%. You don't challenge a judge unless you're ready for her to swing back harder. She pretty much just gave him one sentence and basically checkmated the entire prosecution. Just absolutely brutal stuff here.
My understanding is what I'm trying to articulate is what I'm hearing from the court is the probable cause for the misdemeanor the court is hearing is not the misdemeanor theft we charge. It's receiving stolen property.
I can't even say that. Even in a preliminary hearing, I can't say I find probable cause that a burglary was committed, because the law says I have to determine probable cause of a felony or probable cause of a misdemeanor. If you believe and you want to have the court dismiss all of the counts as it relates to Mr. English because the court found probable cause for a crime, but you're believing that with the four corners, that means the court has to dismiss all because the court's looking at, did he commit that crime? You're putting the court in the spot of being a jury for the court to determine if the facts of the case relate to whether or not Mr. English committed misdemeanor theft, moving stolen property. I am not the jury. Right now, I am just here to determine probable cause to commit a crime. I find probable cause Mr. English committed misdemeanor crimes, at the very least, as it's alleged in the criminal complaint. What the state wants to do with it, the state can do with it. But as to those other counts not stated on the record, I cannot find probable cause. So as of this court's review, all counts except 6, 15, 24, and 33 are dismissed. Whether the state wants to pursue the theft of movable property or to amend to something else, or to amend the whole criminal complaint to find other connections with Mr. English and the burglary and the criminal damage to property charges, the court or the state can. But that's what I'm finding. And again, I think my review and my understanding of case law, my understanding of the statutory law, I believe I'm correct. And again, I'll hear Mr. Harrington. What do you think?
I agree with you, Judge.
The problem I'm running into is if the court is just finding if that probable cause of misdemeanor exists, I don't know why the court dismissed the crim damage and kept the theft, why it did make a decision to choose one and not the other.
Criminal damage is so connected to a burglary because you're alleging that he had the conspiracy to commit that criminal damage of breaking a door or breaking a window or breaking those other things to damage that property. If the court cannot find a connection other than speculation or conjecture that Mr. English, with the facts again, as stated in the criminal complaint, conspired to commit a burglary of a building, the court cannot find that he conspired to commit criminal damage to property. Again, as to the other property, the property that is of issue here, the court can find probable cause he committed a crime. Again, if you want the court to dismiss all of the counts, I surely will.
I want the court to find there's probable cause for all. I'm being careful with my language because I'm trying to figure out if this is a final order finding no probable cause for any of the counts, or if it's, and that the court thinks there is probable cause for some misdemeanor not in the complaint, or if the court's finding that, because the state did not allege receiving stolen property. The
Correct.
state alleged that.
Exactly.
the
I'm going to
state-
tell you, okay, I find probable cause that a crime was committed. I find based upon the charges that are charged right there, removing the ones the court cannot connect to Mr. English, that there's probable cause to believe a crime was probably committed and it relates to the charges that are filed. Again, whether or not the state charged the correct charge, the correct criminal charge, or what the state can prove to a jury is for the state to determine. But I'm not dismissing counts 6, 15, 24, or 33, unless the state asks me to dismiss them all. Then I will. I have no problem doing that.
I do not. I believe there's probable cause for misdemeanor theft.
All right, thank you. Then those counts stand. Anything further?
I have to chat with Mr. English about some things. I'm not sure what this does with the trial on with these other two defendants, frankly.
Well, that's for you to talk to the state and that's for that to be figured out. And here's the thing. I understand that you represent Mr. English. The court needs to have the speedy trial. We're having the speedy trial when it's set. If you can't be here, Mr. Harrington, Mr. English, and he needs to be a part of that trial, Mr. English will then need to get a different public defender.
Thank you, Judge.
That ending was so satisfying to watch. It really shows how much of the justice system comes down to the exact words on the page, not what everybody thinks happened. You'd be surprised how many people end up convicted just because no one bothers to question the paperwork at all. And today, the prosecutor learned the hard way that you can't just walk into court with a half-written complaint and expect the judge to connect the dots for you. Personally, let me know if you guys agree with me, but I just love judges like this. Strict, detailed, and not afraid to call the state out when the report is lazy. It honestly just makes you wonder how many cases would fall apart if every judge actually read the fine print like she does. But yeah, guys, let me know in the comments if you think she made the right call or if she went too far with it. Thank you so much for watching. Make sure to like and subscribe as always, guys. I really appreciate you watching and take.